everyone, welcome back to chapter 8. So this week we're going to move on and we're going to talk about more crime. So last week we talked about parties to crime, which is a form of crime. Remember, being a party to a crime is an actual crime. So what we're going to do this week is we're going to talk about what we call the inchoate offenses. These are offenses that are not quite completed yet. So we will move on and talk about all of the different inchoate offenses. Okay, so just to get us started to think about it, this is a question for you. We already had talked about the elements of crime and that you need to have all of the elements of the crime in order to criminally charge a person to keep the wheel rolling, right? And if we don't have all the elements, the wheel stops. So then I have a question. Can someone still be convicted if they fail to complete elements of the crime? So according to what I've taught you so far, the answer would have been no, you cannot, because you have to have all of those elements to keep that wheel rolling. But we don't like people attempting to commit a crime or trying to commit a crime and just getting away with it. So we have created a whole batch of crimes which are called what we would refer to as the inchoate crimes, okay? So just to get you thinking, here's an example. Dames and his estranged wife, Marjorie, were parked in a restaurant parking lot. Dames asked Marjorie for some money and she stated that she did not have any. They fought, she got out of her car and ran. Dames ran after her. She trips and is lying on the ground. He walks up to her, points a pistol at her head and pulls the trigger. Nothing happens. He begins to yell, it won't fire. Can we charge him with a crime? Now, if we think of the crimes, we would think of murder, right? Well, murder, you have to kill somebody. In this case, there is no killing yet. Nothing has happened. He hasn't hit her. He hasn't touched her. He hasn't assaulted her. So can he be charged with anything? And if we follow that strict rule that all the elements have to be proven to keep that wheel rolling, you would think no. But we don't want somebody like this to just get away with trying to hurt somebody and not having any accountability. So we have created what's called the inchoate offenses. Some people say inchoate. It's fine. It's just different ways to pronounce it. I say inchoate. So the inchoate offenses, there are only 3. So when you're doing your homework this week, these are the only 3 you are allowed to use, okay? The inchoate offenses. And then when you're on the exam and I give you a question and say, pick an inchoate offense, these are the only 3 you can choose from, okay? So the 3 inchoate offenses are attempt, solicitation, conspiracy. We will be going through each of them separately and you'll understand what each of those are. Now, when we talk about these, since they're incomplete offenses, they have to be combined with another offense. So if I say to Joe Smith, Joe, you're charged with attempt. The first question you would ask would be attempt what? Like, what did you attempt? So then you think about it, you have to combine it with another crime, attempted robbery. Now for our homework, we're only going to look at the elements for the attempt part of it. We're not going to look at the robbery because we haven't covered robbery yet, but just understand they all have to be combined with another crime. So attempted robbery, solicitation of murder, conspiracy to commit terrorism, okay? So they would be combined with other crimes, but we're gonna look at them in their pure form this week. We're gonna look at them individually as they are. Okay, so we're gonna start with attempt. Attempt is the most frequently charged inchoate crime. So out of the 3, this is the one you see a lot because a lot of people attempt or start to commit a crime, but they don't actually carry it out, okay? That's attempt. So attempt is when a person with the intent to commit the offense, you want to commit the underlying crime. Your mind, your mens rea is intentional. You want that crime to be committed. You perform a substantial step towards the commission of the offense. So we need to know what is a substantial step, because if you complete the crime, then you're just charged with the crime. So you want to commit the crime and you take a substantial step towards completing the crime, but you don't actually carry the crime out all the way. So how do we define substantial step? So a substantial step is defined under common law as preparation has ended and perpetration has begun. This means you are now in a position right then to carry out the crime. Okay, so you've ended the planning and the preparation and buying the supplies and figuring out what you're doing. You've even gone to where you're going to commit the crime, and you're in a position ready, willing, and able to carry it out at that moment. That's preparation has ended, perpetration has begun. So when you are setting forth the elements of attempt, it's intent to commit an underlying crime, and substantial step, which means you've ended preparation. Your actus reus is substantial step. So you've ended preparation and begun perpetration. Okay, so let's look at an example. You are in your apartment planning to kill your boyfriend and your best friend because they cheated together. You go to your room, and you get a gun, you pick up your keys, you go to your car, and you realize what you are doing, so you change your mind and go back to bed. So the question is this an attempt? You did want to do it, you thought about it, you intended to commit the underlying crime, but did you take a substantial step? Had you ended preparation and begun perpetration? Well, no, because you aren't in a position to carry it out. You haven't gone anywhere. You're not in the place to carry it out yet. So this is not attempt. You didn't go far enough. So same scenario, you go to your bedroom, get your gun, load it, you get in your car, you drive to the apartment. When he answers the door, you get out your gun and pull the trigger. You are shaking so bad you miss. Now, is this an attempt? Yes, you still intended to commit the underlying crime. You now have ended preparation and begun perpetration because you were in a position ready, willing, and able to carry out the offense, and you just didn't do it. That's when it's attempt. So you have to be that far along in order to charge somebody with attempt. Okay, so how close is close enough? How close do you need to be for that substantial step? So is just buying a gun enough? Is starting to make a bomb enough? Is collecting tools for burglary enough? And in all of those, none of them would be enough. And they would not even be enough in New York, because New York makes you be even further along. So common law, it's a substantial step. In New York, you have to be very near completion. They call it the dangerous proximity test. What it says is you are dangerously close to succeeding at your task. So the last example, you pull the trigger and you miss. That's dangerous proximity test. You were super close at succeeding, okay? If you were walking up the sidewalk and you tripped and you didn't actually get to the door yet, maybe that, and you change your mind and leave, that might not be enough for dangerous proximity test. You have to be dangerously close. So in New York, remember, we often give more rights to the defendant. We're going to make the defendant be even that much closer to carrying out the crime before we'll be allowing them to be charged with attempt. Okay. Now, Barney decides to kill Jeffrey. He buys a gun, is driving around town, and is looking for him, but cannot find Jeffrey. A police officer becomes suspicious and arrests Barney. Can Barney be charged with attempt under common law? So, did he have the intent to want to commit the crime? Absolutely. Substantial step. Has he ended preparation and begun perpetration? No, because he's not in a position to carry it out yet. He has not found Jeffrey. He cannot carry it out at that moment. That is not a substantial step. In New York, dangerous proximity test is even further than substantial step. So if you can't prove it under common law substantial step, you definitely cannot prove it under New York's dangerous proximity test. Okay, Larry decides to murder Vern. He buys a gun, finds him at home, and shoots him. Although the first shot misses, he kills him with the second bullet. What will Larry be charged with? So in the first time when he finds him and shoots at him and misses, right? He intended to do it. He took a substantial step. He had ended preparation, begun perpetration. In New York, he was even dangerously close to succeeding. So you have attempt. Now he actually does it again and he carries it out and succeeds. Now you have some level of homicide, murder. So now what happens, right? So now you have an attempt charge for the first bullet, a murder charge for the second. Can you be charged with both an attempt and the murder? And the law says no. Once you actually have completed the underlying crime, it merges with the crime you wanted to commit, so the murder. So the attempt goes away and you're now just charged with the underlying crime. So as soon as you are successful at completing the underlying crime, then you will be just charged with the underlying crime. Okay? Now, Jane walks into her bedroom and shoots her husband after finding out he cheated on her. She unloaded 5 bullets into his chest. Unbeknownst to her, the husband had already died of a heart attack an hour earlier. Can Jane be charged with murder or attempted murder? So, intent to commit an underlying offense, you wanted to commit murder, and you unleashed bullets. So the first thing is, did she cause the death? No, because he was already dead of a heart attack from before. So she could not kill him, he was already dead. So you can't charge her with murder. But can you charge her with attempt? Did she intend to do it? Yes. And was she dangerously close to doing it? Yes, if he had been alive. So you may be able to charge him with her or charge her with attempted murder. Okay. Now, there can be what's called a factual impossibility. It is factually impossible to kill or commit the murder because the person was already dead. What the law says is you cannot use that as a defense. So sometimes you'll see in the penal law when we're looking, you'll see a section that says no defense. That is when New York takes away a defense. What happens with attempt is the law takes away your claim of factual impossibility. You cannot argue, well, I couldn't have succeeded because the person was dead, so you can't even charge me with attempt. The law says, nope, we're not going to let you say that. You can never use factual impossibility as a defense for attempt. If you have the mental state, the intent to commit the underlying crime, and you are dangerously close to completing it, even if the person was dead, then you're going to be charged with attempt. Maybe not the underlying crime. You're going to be charged with the attempt of it. It would have been a crime if the facts had been different. So you did attempt to do it. So this is a defense that they take away. Okay. What about this? Bobby decides to rob a bank. He purchases a weapon, walks into the bank, and changes his mind. Is that an attempt? Right? So did he intend to do it? Did he have the mental requirement to do it? Absolutely. He wanted to do it. Did he take a substantial step? Had he ended preparation and begun perpetration? Well, he actually had, because he went to enter the bank. So he was in a position ready, willing, and able to carry it out at that moment. So it would have been an attempt, right? Can he change his mind? Will he still be criminally liable? Well, the law does give people one defense, an additional defense to the ones we learned. It's called an abandonment. So we learned in the defenses chapter all of the standard defenses. Those were the standard justification and excuse defenses. Abandonment is a specific defense that goes along with attempt. Abandonment means you change your mind and leave the crime uncommitted. Now, in order for abandonment to be a valid defense, you have to do it voluntarily. So there can't be an outside force that causes you to give it up at that moment. So there's police staked out front with guns, something like that, and you see it and you're like, oh, I'm not going to do it right now. That is not abandonment. It has to be that you just choose, you change your mind voluntarily and choose not to commit that crime anymore. Okay, so that is all the common law rules. Now we need to look at the New York penal law and figure out what the New York penal law says about attempt. So you should grab your penal law and you should look up the definition of, or you should look up the crime of attempt in the New York penal law. So you flip to your index, find attempt, and find it in your book. Once you find it, now we have to pick out the elements. So in the last class, we talked about putting all of it together. We talked about the format that you're going to use for all assignments from now till the end of the semester. So that's what we're going to go over, because you're going to need to remember this format. So remember, the first thing is you find your crime, you read your crime, and then you identify the elements. So let's find attempt and identify the elements. Now, when you find attempt, you will see that when you read the statute, you will have to pick out what mens rea you think that it is requiring. Now, remember, mens rea, you only have 4 choices. So when I write the words mens rea, you only have 4 words you can give me: intentional, knowing, reckless, or negligent. It's only going to fit one of those. So out of them, which one do you think attempt requires? So a person is guilty of attempt with intent to commit a crime. It tells you right there. So mens rea is going to be intentional, intent to commit a crime, just like we said for common law. And then it says he engages in conduct which tends to affect the commission of a crime. So you intend to do something to commit a crime. Now, you will see in my book at the very bottom, I wrote dangerous proximity test. Remember, in New York, you have to prove dangerous proximity. So I recommend you write it right in the book under the law. So you remember every time when you're talking about actus reus, you are going to talk about dangerous proximity because it has to be part of your answer if you choose attempt in New York, okay? So we now know in New York, mens rea is intent and actus reus is intentional, and actus reus is engage in conduct to affect the commission of a crime, the actus reus, okay? Now, how does the crime being attempted affect the punishment? If you look at the next section, and I actually highlighted it so I won't forget it, you will see that when you attempt a crime, it's going to drop 1 class from what it is for all crimes except A1 and A2, A1 felonies, okay? So in general, if you're attempting a crime and you don't complete it, they're going to drop it 1 class. So if the underlying crime is a D felony, it's going to turn into an E felony when it's just attempted. And you will use the sentence range for the 1 class lower, okay? When you look at it, it says class A1 felonies based, and then they list what they are, stay A1 felonies. So there's certain crimes, if you attempt, they're going to stay A1s. But the other ones and certain A2s are going to stay A2s. I was right, okay? But if it's not a listed A1 felony, so when you see 3, it says it's a B felony when the crime attempted was an A1 felony. So I just write it backwards, it gets confusing. So look, if you look at the number 9, class D felony, oh, sorry, let's go to 8. Class B, some of them are confusing. Go to 5, sorry. Class D felony when the attempted class is a class C felony. It's just right. It's instead of saying when you try to commit a class A felony, it turns into a D felony. They just reversed it. It says it is a D felony when you're attempting to commit an A felony. So remember, you're going to drop 1 class when it's just attempted, and that will help you find your sentence range. The last one. The defense listed, what is no defenses? So I told you, and you'll see I highlighted that so you won't forget it, that there are certain times the law takes away defenses. So when you read section 110.10, it says if a conduct which a person engages otherwise constitutes an attempt to commit, pursuant, and it is no defense that a prosecution for an attempt can be charged, blah, 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 it's factually or legally impossible. So I wrote right under that section, factual impossibility. That is saying you cannot claim factual impossibility as a defense for attempt. The law takes it away from you, okay? So now what I want you to do is I want you to try to do a case study. So we learned how to do them in the last class. Now we're going to put them to work again. We're going to be doing them this way through the rest of the semester. So Jackie and her husband, Bob, are getting divorced after years of domestic abuse. Bob cannot live with the fact that she is leaving him. One night, he sneaks over to her house, cuts the phone lines, and sprays gas all around the house. He then sets the house on fire. Luckily, Jackie's dog begins to bark, so she's able to jump out the window of the side of the house prior to the fire spreading. Bob is arrested. What Inchoate crime could you charge Bob with in this case? Now, clearly he committed arson, but arson is not an Inchoate offense. So when I say what Inchoate crime, you only have three choices: attempt, solicitation, conspiracy. And we haven't covered the other two yet, so you have to know that the Inchoate crime is attempt. So what I want you to do is stop the video and try to write out how you would do a case study, like putting it together like we did for this example. So you look up the crime and you write attempt and you write the section. Then you write mens rea, and what's the mens rea out of the statute? Actus reus, what's the actus reus? Why? Why did you pick this crime? Proof. How would you prove it? What evidence would you use in court to prove this? And then defenses, and then class, and then sentence. So stop the video, try to work through each of those categories, and then when you're done, start it, and we'll see if you got it right. Okay, so hopefully you did it. So the crime we know is attempt because that's the only one we've covered so far. So we write attempt and we write the section number. Now we need the mens rea and actus reus as written in the statute. So we already went over that in class. We said the mens rea for attempt is intentional, intent to commit a crime. Okay, so it's an intentional mens rea. Actus reus engages in conduct effectuating the commission of a crime. We already said that. We already talked about that's the same thing. So every single time you choose attempt, those are going to be the same. They're never going to change. It's always going to be intentional mens rea. It's always going to be engaging conduct affecting the commission of a crime for your actus reus. Proof. Now remember, for proof, you have to have evidence for each element. So you really need to break each element down and identify what proof you would use to prove each element. So we know mens rea is intentional. How do we show intentional? Remember, we don't have thinking hats. We can't use mind reading to figure it out. So we have to use actions. What did the defendant do? What do we know that shows that the defendant intended to do it? The wife's testimony, the gasoline investigator testimony, showing that it was a deliberate dumping of gasoline. Actus reus, engage in conduct to commit the crime. How do we prove that the defendant did that? Witness testimony, wife testimony, maybe there's video camera, accelerant evidence. Those are the pieces of evidence that we have to present to the jury to show that the crime was committed. Now, I'm not asking you to explain what happened. Many people in the proof part want to say, well, he got gasoline and dumped it all around. That's an explanation. That's not evidence. And at trial, you can't just explain to the jury. You have to show them physical evidence, witness testimony, proving that those things occurred. So you have to think in terms of evidence to a jury. Now, why? Why did you choose attempt? Well, kind of because it's the only one we covered yet. But when you write it out, why is the most important part of your case study? This is where you convince me that you understand what the crime is. So for attempt, you're going to have to talk about first a couple things. You will learn with solicitation and conspiracy, there has to be two people always involved for those crimes. So when you choose attempt, the first thing you could say is, well, there's only one person involved, so it could not be conspiracy or solicitation. So number one, you're going to tell me why you chose that particular Inchoate crime over the other two. Then you're going to tell me why attempt. Why does it fit attempt? This is where you have to talk about that dangerous proximity test. So remember, I told you to write it in your book. This is where you're going to say, I chose attempt because he fit the dangerous proximity test. Explain to me, how was he very near completion? This is where that needs to be explained in your why, okay? Now, defenses. We covered defenses in 2 chapters, and sometimes there'll be additional ones that I introduce. So maybe you choose for this one, insanity, that he lost his mind. If you choose, and so for defenses, don't forget, you got to do 3 things. Identify the defense. It has to be a defense we learned in class. You can't make up some random thing. You have to use the terms and concepts from class. So insanity. So you name the defense. You have to define what's required of that defense. If you remember, I gave you the defense charts. You can use those. It sets this out. Name of the defense, what has to be proven for that defense, and then whether or not you think it will be successful. So insanity, I'm using the irresistible impulse test, which is mental defect plus inability to control yourself. He was so distraught over the divorce, he couldn't control himself. It would not be successful because there's no way to prove that he actually suffered a mental defect. So make sure you include all three. Now you need your class. So it was attempted murder, right? Because he already committed arson. So now he was attempted murder. So we need to look up what is murder. So murder is an A1 felony. Now, when we go back to attempt, we look up A1 and it says an A1 that is murder stays A1. So A1 stays A1. And so therefore we class A1. And we know the sentence range for A1 is 15 to 25 years minimum to life in prison maximum. Okay, so hopefully you got that. If not, look back over the materials and watch it again and try some of the problems later, and hopefully it will help you. So let's move on to the next inchoate offense. So that's attempt. The next one is what we call solicitation. Solicitation requires two people. So remember I said the other next two inchoate crimes are all going to require two people. Solicitation is one person persuading or getting another person to commit the crime. Now, with solicitation, the person soliciting does not want to commit the crime themselves. Ew, gross, that's gross. I'm not going to do that. I want somebody else to do it. That's how I think of it in my mind. So solicitation is encouraging or getting someone else to commit the crime. Oftentimes you hear murder for hire. You pay somebody else to commit the murder. You don't want to be part of the murder. You just want it done, so you're getting somebody else to do it. That's solicitation. Now, what about this? Abel pays Barnes to commit murder. Solicitation? Absolutely. One person getting somebody else to commit the crime. Abel's not going to be there. Abel's not going to commit the crime. They're just paying somebody else to commit the crime. That is classic solicitation, murder for hire. Now, Correctional Officer Smith gives a note to inmate Bubba requesting that Bubba kill inmate Trouble. Before Bubba is able to even read the note, it was confiscated by Superintendent Smith. Okay, so is it solicitation? So the idea is, if my request never reaches the person, is it still solicitation? So I'm going to ask somebody to commit a crime, but my question, my asking never reaches the person. Does that qualify as solicitation? And the answer is no, because the person never received the request, but it can be attempted solicitation, okay? Now, Andrew solicits Bob to murder Carl, and Bob carries out the task and murders Carl. Now, what would Andrew be charged with? So you solicit somebody to do it. What happens to the crime when that person actually carries it out? It's just like attempt. It merges with the underlying offense. So before it would be solicitation, but now that it's completed, you're now an accessory before the crime. So think back to what we learned about accessory. You wanted to commit the crime and you aided in some way to commit the crime. So you were actually an accomplice to murder. And once the crime is committed in New York and you're an accomplice, you get the same treatment as the principal. So you are going to be charged with the murder. So if you solicit somebody to commit a crime, once they commit the underlying crime, you are charged with the underlying crime, just like the principal was charged, because you solicited it in the first place. You become an accomplice to that crime. Now, what if Bob refuses? So you solicit Bob to kill Carl, and he never does it. What can you charge the person with? That's still solicitation. the person you request to do the act doesn't actually have to carry the act out. Just requesting the person to carry it out is the solicitation. So as soon as you ask the question and you want them to do it, that's the solicitation, even if the underlying crime is never carried out. Okay, so let's look at this example. Carrie and Sam are talking one day, and Sam says he is furious with his wife, saying in the conversation, "I would pay anything for her to just disappear." The next day, Carrie shoots and kills Sam's wife. When arrested, Carrie tells the police that Sam encouraged her to do it. Can you charge Sam with solicitation? Is this enough? Is this really intent to have Carrie carry out this crime? Did the person really request and intend for the person to carry out? This gets a little trickier, right? Because the problem with that, oh, sorry, I guess I went too fast. The problem with that is we have to show that that Carrie knew what Sam wanted, that Sam really intended Carrie to carry that out. So we may have problems with mens rea in this case, because maybe it's not intentional. Maybe he was just talking, and just said something at the heat of the moment, and there really was no intent to carry it out. So this is going to be a much harder case to prove as a prosecutor. So you may need more evidence to show that Sam actually intended for this crime to be committed. Okay, now just like abandonment was a defense for attempt, we have an additional defense for solicitation, and it's called renunciation. So remember, with attempt, there's only one person, so they can just change their mind and leave. But when it comes to solicitation, you've already involved another person into committing the crime. It took two people. So for renunciation, you have to completely voluntarily change your mind, just like we did for attempt, but you also have to prevent the crime from being committed. So the only way to really do that is to go to the police and get the person arrested. Now you might say, well, why would I ever do that? That would just, implement myself, and then I would get arrested for doing it. You might, but at least you'll be charged with the lesser offense of solicitation instead of the underlying crime that if it's actually completed. So renunciation is you completely and voluntarily change your mind and renunciate the crime, and you keep the crime from being committed. You have to have both things in order for it to be a valid renunciation. Okay, so we looked up attempt, and we were lucky because in New York, we only have 1 degree of attempt. Now we're going to look up solicitation. So we're going to start with solicitation 5th degree, just because that was the simplest, and we'll see how it changes with other degrees. So what I want you to do is stop the video if you have to, look up solicitation in the 5th degree. Okay. Now, once you have it, we need to pick out the elements, just like we've been doing for every crime so far. We learned actus reus, mens rea, and then we did it for parties of crime attempt. We need to know for solicitation 5th, what would be the mens rea? So a person is guilty of criminal solicitation in the 5th degree when, with intent that another person engage in conduct constituting a crime. So mens rea, intentional. Intend somebody else to commit a crime. Right? So mens rea is always going to be intentional. Actus reus, solicits, requests, commands, importunes, or otherwise attempts to cause another person to engage in such conduct. So those are all or. So you either solicit or request or command or importune or attempt. So any of those, another person to commit a crime. Okay, that's your actus reus. That's always going to be your actus reus. Now, do they take away any defenses? So if we look at section 100.15, it says a person solicited could not have been guilty of the crime solicited owing to another defense. So this can become problematic. What if I solicit a 4-year-old to commit a crime? Can a 4-year-old be convicted of a crime? The answer is no, because of the infancy defense. Now, do I get out of solicitation since I solicited somebody that couldn't commit the crime? If I don't have the person that I solicit can't be convicted, well, I shouldn't be able to be convicted either. The law says, yeah, no, we're not going to let you do that. It doesn't matter if the person you solicit has a valid defense or not. You can still be charged with that offense. Okay? So it takes it away. Now, how does it differ from other degrees? So if you now flip back, we talked about the lowest degree, 5th degree. Now look at 4th, 3rd, 2nd. What makes it go higher? What are the factors that make it go a higher degree? So spend a few minutes reading each of them and figuring out what makes it be a higher degree. Hopefully you'll see it depends on the age of the person you solicit. If you solicit a younger person, it's going to be a higher degree. Also, the crime that you're soliciting to be committed. If you're asking somebody to commit a felony, it's going to be a higher degree than if you are asking somebody to commit a B misdemeanor. So you need to know the age of the parties. You need to know what crime is being solicited. That will help you choose your degrees. Okay, so now that we know all of that, let's try a practice one, just like we did with attempt. So Jackie and her husband Bob are getting divorced after years of domestic abuse. Bob cannot live with the fact she is leaving. One night he's out drinking with his buddies, crying over the end of his marriage. He says how much he hates her and just wishes she was dead. After too many drinks, his buddy Fred goes to Jackie's home and tries to strangle her in the living room. Fred is arrested and charged with attempted murder in the 1st degree. What Inchoate crime could you charge Bob with in this case? So we have 2 people. We have Bob, we have Fred. So now we can charge a different crime other than attempt. We have Bob asking another person to commit a crime, Fred, right? So we now think, okay, it's probably solicitation. Bob isn't going to do it himself. He wants somebody else to do it. So we're going to fall under solicitation. So now we have 5 degrees of solicitation. We need to read through them and figure out which degree. So spend a few minutes, pick your degree, then write the mens rea, actus reus, proof, why, defenses, class, and sentence. And see if you got it right. Or write it all down and then click to the next slide and see if you got it right. So stop the video and start it when you're done. Okay, so I picked solicitation 2nd degree, and we'll get to why I picked it. If you pick something different, as long as it fits, the law fits, it's okay. This is the highest degree, though, that you could charge with, okay? We want to always charge the highest possible. If we're a prosecutor, we always want to charge the highest possible. So mens rea, we know for solicitation, it's always going to be intentional. Intend to commit a crime. Now, for 2nd degree, it's not just intent to commit a crime, it's intent that the other person engage in a Class A felony, okay? So we know that the person is charged with murder. That's an A felony. So we know we can fit the mens rea for this. So intent to engage in a Class A felony. Solicits, requests, commands another person engage in an A felony. Those are our actus reus. They're always going to be the same, no matter what the facts of the case are. That's what the law says you have to prove. Now, how do we prove it? Intentional. Well, we can show intentional by having people testify that what he said at the bar. Witnesses, friends can take the stand and say, no, he told us he wanted us to do it. How do we show solicit requests? Again, friends' testimony saying they heard it, witnesses overhearing the conversation. You can use the same piece of evidence for more than one element. That it was another person. We have witnesses. A Class A felony, we'll have the witnesses, we'll have bruises, we'll have the police reports. All of those will show that it was an A felony. So we have evidence for each individual element. Now, why? Why did we pick solicitation? Now, remember, the why is always going to have 2 parts. Why this inchoate crime over the other, and why the degree that you picked. Okay, so why did we pick solicitation over attempt? Well, because one person is asking another person to commit the crime. That is the classic definition of solicitation. But Bob was not going to participate in this crime himself. He wants somebody else to do it. Now, why did you choose a second degree solicitation? Well, because the underlying crime was an A felony, and solicitation second requires an A felony, and then the ages fit. Now, do not write because it fits the elements. That does not tell me that you really understand. This is your chance to convince me that you really do understand the differences between the different degrees. If you say it fits the elements, that doesn't tell me anything, right? That's like saying food. What'd you eat for dinner? Food. Well, that doesn't tell me anything. If it's the elements, that doesn't tell me anything. Make sure that you specifically tell me why it fits the elements. Explain. Now, defenses. You could argue negative, that he didn't really mean it. There's really no intent. You could negate the element of intentional. It may or may not be successful. You could show withdrawal or renunciation, that he renounced the crime and he should have kept it from occurring. But in this case, he didn't try to keep it from occurring. So it would be not a valid defense. Now, since it's a solicitation, it has its own class, where attempt didn't. You had to use the class of the underlying crime. In this, solicitation second is a D felony. And then when we look up the sentence range for a D felony, it's 1 to 3 to 7 years. 1 year minimum, 3 to 7 years maximum. Okay, one more, conspiracy. Conspiracy is similar to solicitation because it requires two people. But instead of one person getting the other person to commit the crime, both parties are going to actively play a role in committing the crime. So conspiracy is an agreement between two or more people to commit an unlawful act. So for conspiracy, you need an agreement. Doesn't have to be written or signed. It can be an oral agreement. So an agreement. You need at least two people, and that agreement is to commit a crime. You need all three of those things in order for it to be a conspiracy. Now, for conspiracy, it's a little different. There's one more additional thing that has to be proven with conspiracy. You have to show that there was an overt act. So that means one person did one thing towards committing the crime. You don't have to have it be a substantial step. You don't have to be dangerously close to success. You just have to have one person doing one thing towards the conspiracy. So I talked to my friend and we decide we're going to burn down the school. So we have an agreement between two or more people to commit a lawful act. The second one of us does something towards committing that crime, anything, even something small, as soon as we take a step forward in the planning process, we now have conspiracy, and that's what we call an overt act. Okay, so three guys are playing cards, decide that they need a little extra money so they can go to Vegas and enter high stakes gambling. They agree to rob a Brinks truck. A decides to get a car to drive for the escape. B decides to get a gun to scare the guards into turning over the money. And C will buy Halloween masks to conceal their identity. So the first question is conspiracy. Was there an agreement? Yes. Between two or more people? Yes. To commit an unlawful act? Yes. Rob a Brinks truck. Now we have to say, were their actions enough to qualify as an overt act? One of them has to do something towards carrying out that conspiracy. So, did they get a car? Did they buy masks? Did they get guns? The second one of them completes their task, then you have a conspiracy, but not until one of them does something to carry out the conspiracy. Now, Patrick, Paul, and Quentin decide to rob a bank. Paul is driving the car, so he never goes into the bank. During the robbery, Patrick shoots and kills one of the tellers. is Paul responsible for the murder of the teller? So Paul is just outside. Paul never goes into the bank. Is Paul still responsible for what happens in the bank? And this is what we call the Pinkerton rule. The Pinkerton rule is the act of one is the act of all. So the second once you have a conspiracy, one person's actions fall on everybody else. Even if Paul said, don't bring guns, even if Paul said, don't kill anybody, even if Paul thinks they're using water guns, it doesn't matter. If another person in that conspiracy carries out one of the, a crime, Paul is responsible. Pinkerton rule. Act of one is the act of all. Now, Jamie and Will decide to engage in sexual relationship, even though they're both married. Can they be charged with conspiracy to commit adultery? So adultery is engaging in sexual intercourse when one or both people are married to somebody else. So it's adultery. Is it conspiracy to commit adultery? Well, two or more people agree to commit unlawful act. Yes. But how many people are necessary for the crime of adultery? You need two people. So that means every time that you would have adultery, it would also be conspiracy to commit adultery. The law didn't like that. So the law basically says in Wharton's rule, if the crime itself requires two people, so consensual sexual acts like adultery, bigamy, polygamy, if it requires more than one person, we're not going to allow you to be charged with conspiracy for that crime. That's Wharton's rule. We're not going to pile on the charges. So if the underlying crime requires two people, you can't charge them with conspiracy on top of the underlying crime. Okay, so another issue. Remember we said with attempt and solicitation, as soon as the underlying crime was committed, the Inchoate crime goes away and you're only left with the underlying crime. So if I attempt to murder and I actually kill the person, I'm charged with murder. If I solicit murder and the person I solicit commits the murder, there's just murder. Conspiracy doesn't do that. Conspiracy does not merge. So if you're charged with conspiracy, you can be charged with both conspiracy and the crime. So you can be charged with both. So conspiracy does not merge. So if you engage in a conspiracy to commit murder, you're going to be charged with conspiracy. And even if the murder is carried out, you're going to be charged with the murder. So you're going to be charged with both. Both are going to stand on their own. They're not going to merge together. They're going to stay separate. And you can be charged with both crimes. Okay. Now, Johnny and Susie conspire to commit burglary. They are arrested before they enter the home. Susie's tried first and is acquitted. Can Johnny still be charged? So we have a conspiracy. Two or more people agree to commit an unlawful act. What if one of them is tried first and is acquitted? Can we still charge the second person? And the law says yes, okay? You do not have a defense. I had a slide up. You do not have a defense against being charged just because your co-conspirator gets off on the charges. You can still be charged. Okay? I don't know why I did that. Okay. Now, I just want to cover a couple quick ideas with conspiracy. When you're talking about conspiracy, they're usually very large things. Almost all of these are federal investigations because they involve a lot of people. If they're small, it's okay, but usually conspiracies are very, very large crimes. So you're really talking about large federal FBI investigations. Now, when you're talking about large conspiracies, there are two different forms that most people talk about. The wheel. The wheel is when you have a center person and everybody knows who that center person is. And then they have all these offshoots of people that are you're trying to commit the crime, okay? So the mafia or organized crime, you have the kingpin, the boss, the godfather, and then there's all these branches that come off the godfather that are committing unlawful acts. And they all kind of know about each other and that they exist. A chain is different. A chain is when there are a series of people in the conspiracy but you may not know other people. You may not know that they exist. You kind of only know the person in front of you and the person behind you, but you don't know the whole links of the chain. So that is another form of conspiracy. You have to be able to link all of those people back into the conspiracy. Now, conspiracies are super, super hard to prove because you have to link this chain back and you have to show intent through all of those layers. And during organized crime and trying to investigate and prosecute, it was always very difficult to get at the godfather of the crime. So eventually the federal government passed what's called RICO. And you don't have to know the whole thing, but RICO is Racketeering, Influence, and Corruption Act. You need to know that RICO is a federal law that was created specifically to help prosecute conspiracies, okay? So it created a little bit easier rules to go after the high people in conspiracies, and it made more enhanced punishments and things like that. You usually see RICO in cases of organized crime, mafia, large white-collar crime organizations, and then governmental corruption. So there's where you will see RICO being used. So you don't have to know everything about RICO or the elements or anything like that. It gets really complicated, but you need to understand that RICO is there to help sort of go after large form conspiracies. Okay, and just like we had for solicitation, the defense of renunciation, we also can use that for conspiracy. So again, withdrawal and renunciate, meaning going to the police so that the crime, the person can be arrested and no longer ever be charged with that crime, or to stop the crime from occurring, sorry. Okay. So let's just think about this, apply what we know. Two gang members are drinking one night and discuss murdering the gang leader. They never take any action. Are they guilty? No. So we do have an agreement between two or more people to commit an unlawful act. But why isn't it a conspiracy? No overt act. Nobody actually took steps to do it. Two wealthy businessmen discussing murder their boss over martinis. One of them contacts someone they believe is a hitman. They never carry out the murder. Conspiracy. Two or more people? Yes. Agreement? Yes. Commit unlawful act? Yes. Was there one overt act? Yes. They made the phone call. This could be conspiracy. Okay. So now, just like we looked at with the other two Inchoate crimes, attempt solicitation. Now let's look at one of the degrees of conspiracy. So let's look at conspiracy second. So stop the video, look up conspiracy second. When you're ready, start the video. Okay, conspiracy second, a person's guilty. Conspiracy second, when with the intent that conduct constitutes an A felony be performed, he agrees with one or more persons to engage in or cause the performance of the conduct. So mens rea, intent to commit an A felony. Okay, this is specific to second degree. Intent to commit a felony. Okay, an actus reus, agree, one or more people, so two or more really, ultimately, and engage in the performance of the conduct, which would be a crime. Okay, just like what we said. Now, when you flip and you look under 105.30, no defense, the same thing as solicitation. Just because your co-conspirator has a valid defense doesn't keep you from being charged. So you can still be charged even if your co-conspirator has a valid defense. Now, what I really want to look at is 105.20. 105.20 says, a person shall not be convicted of conspiracy unless an overt act is alleged and proven. So what that is saying, all of our sections of conspiracy, even though they have different requirements, on top of what it says in here, you also have to show overt act. So if you will see, I wrote overt act after each section. So you never forget that overt act is a required actus reus. So now when you list your actus reus, mens rea, intent, actus reus, agreement, two or more people to commit a crime, and overt act. You have to include overt act because of 105.20. Now, Let's look at some of the other degrees. Fifth, fourth, third, first. Why are they different from second? It's going to be similar to solicitation. The age of the people involved in the conspiracy and the degree, the class of crime that the agreement is to commit in the conspiracy. So we just did this with the other ones. Now we'll try it with this. Ed and Jesse, 24 years old, meet in a cafe about robbing a bank. They agree, but they decide to think about it longer. The next week they talk again. Robbery is an A felony. They decide to pull the robbery the next Friday in 5 days. Ed says he'll get the gun and car. Jess said she'll meet at the crossroads. Someone at the table overhears the bank and calls the sheriff and arrests Jesse. So do your case study. Find your degree, mens rea, actus reus, proof, why, defenses, class, sentence range. So stop the video, and when you're ready, you can turn it back on and see if you got it right. So I settled on conspiracy second degree 105-15. Make sure you write the name and the section number. Mens rea, intentional. Intend to engage in an A felony. Robbery is an A felony. Actus reus, agree two or more persons, engage in an A felony, and overt act. See that I include it right as an actus reus. You can identify your proof, intent, witnesses, video cameras. Actus reus, there's an agreement. You have witnesses that heard them agree, two or more people. You have police reports, video, conspiracy, and then engage in a felony, the police report, the penal law, and overt act. So this may be problematic, and we'll talk about that within defense, but we need somebody to testify that they took a step towards carrying it out. So maybe they made a phone call, maybe somebody did something towards committing the conspiracy. Okay, why? Now, number one, why conspiracy over the other two crimes? Well, there's at least two people, so we now know we're solicitation or conspiracy. Why not solicitation? Because all three parties are part of the crime. They're all going to be participating. It's not one person trying to get another. They're all agreeing on the conspiracy. Why second degree? Because it's an A felony and because of the age of the people involved. So remember, your why has two parts to it. Make sure you include both parts. Defenses. Now, you may have been saying when you were writing your elements, overt act. I don't think there's an overt act. How do I prove overt act? So you may have a valid defense, the defense of a negative defense. You can't prove overt act. If you can't prove overt act, you have no conspiracy. This might actually be a successful defense. Now, it's conspiracy second, and you look at it, it's a class B felony, and that's 1 minimum to 3 to 25 maximum range. Okay, so now just to put it all together so you clearly understand the distinctions between the three Inchoate crimes. Read each scenario and decide which Inchoate crime would it be. So Harry pays Reed $100 to shoot his wife. Jake and Lola plan to kill the criminal justice teacher. They locate her office. And Greg buys gasoline and tries to burn down his ex-girlfriend's apartment. Decide which Inchoate crime applies to each. So when you're ready, or stop the video. When you're ready, start it again. Okay, so Harry pays Reed to shoot his wife, solicitation. Jack and Lola plan to kill their teacher, conspiracy. Greg buys gasoline and dumps it in his or her apartment, attempt. Okay, now try these three. William encourages Ed to have sexual relations with a drunk girl. Anne contacts Ross and they agree to rob the bank. Anne purchases a gun. Peter poisons his partner's meal, but the partner does not eat it. So first one, solicitation. Second one, conspiracy. Third one, attempt. Okay, now, if you need any more practice, I posted practice problems. You can work on them, and I posted a key so you can work on them and then compare it to the key and see how you do. So just as a refresher, remember, the first thing you do is you read the scenario and decide how many people are involved. If it's only one, you only have one choice, attempt. If there's two people, then you have to decide, are both people actively going to participate? That's conspiracy. Is one person just trying to get another person to do it, but they're not going to do it themselves? That's solicitation. So always go through that thought problem when you're working on it. Now, one of the things that I posted online is a reference sheet, and I posted it for parties to crime, and I will post one for every single category of crimes that we do from now on. I highly, highly, highly recommend you print this out, because this is going to be very, very useful when you're doing your homework and when you're on exams, okay? So what it does is it takes the 3 crimes that we talked about, and it gives you the common law definition, and then it gave you the differences for New York. It talks about dangerous proximity test, so you remember it, and it even gives you a clue about sentencing. And then solicitation, it tells you the different sections, and then the class, you need the class of the underlying crime and the age. And then conspiracy, it talks about the requirements, overt act, the 2 rules, and then New York, the sections and how you decide between the different degrees. So I highly recommend you keep this with you and you use this as a helpful reference. You can use it on homework, you can use it on exams. It should be a way to help you remember how to do it. Okay, so I know it's a little long. I just did it all in one instead of breaking it into 2. But hopefully that helped. And next week we will move on and we will talk about homicides. Our next chapter talks about homicides. So have a good day, and I will see you soon.